We now come to the question that Clause 30 stand part of the bill, which it will be convenient to debate Clause 37 stand part. The question is that Clause 30 stand part of the bill. Minister?
Chair, I rise to speak to Group 31. Group 31 concerns the regulation of independent educational institutions. I turn to Clause 30. All children should receive the best chances in life, an education which helps them to achieve and thrive. And to support this, it's already a legal requirement for private schools to register with the Secretary of State. Registered schools are regularly inspected and action is taken against schools which potentially put children at risk of harm by providing an unsafe or poor quality education. Clause 30 will bring some more settings that provide a full-time education into this well-established and effective regime. This will lead to more children learning in a regulated and safe setting, which is subject to regular inspection. At present, private schools are regulated mainly by Chapter 1 of Part 4 of the Education and Skills Act 2008, and this Act allows private schools to be subject to regular inspection, regulates the changes that they may make to their operation, and provides mechanisms to allow the government to intervene in cases of severe safeguarding risks. Clause 30 redefines the settings which are to be regulated by the 2008 Act, and so extends these protections to more children who attend full-time educational settings which are not schools. It will also provide clarity to those running educational settings about whether the regulatory regime applies to them. In broad terms, settings will be required to register with the Secretary of State if 5 or more children of compulsory school age or 1 or more such child with an EHCP who is looked after by the local authority could be expected to receive all or a majority of their education at the institution. When determining whether this new test of full-time is met, the factors found in section 94.4 of the clause will be considered. Finally, in the interest of clarity, the clause provides a list of accepted institutions. Accepted institutions are not being brought into scope of the 2008 Act, even though they otherwise may meet our new definition. Generally speaking, this is because they are already captured by a suitable regulatory regime. I now turn to Clause 37. Clause 30 is intended to ensure that more settings which provide full-time education to children are subject to regulation. There is, in addition, other legislation which already applies in England in relation to independent schools, but which will not automatically apply to other independent educational institutions. Further legislation will be required if it is to apply to all of the settings regulated under the 2008 Act. Clause 37 provides a regulation making power to do this and apply other legislation which applies to independent schools over and above the Education and Skills Act 2008 to other full-time educational institutions. This approach is proposed for 2 reasons. First, because it will permit Parliament to debate the principle of bringing the independent educational institutions into the existing regulatory regime in the 2008 Act for independent schools. Second, it will allow Parliament to separately debate the practical impact of this with regards to the other individual pieces of legislation. That is because any regulations made under this proposed power will be subject to the affirmative resolution procedure. Parliament will have the opportunity to scrutinise and approve any regulations made under this clause. Clause 37 is a mechanism to allow these changes, which might be regarded as downstream from Clause 30, to be made. Turning back to Clauses 30, this is a reasonable and proportionate step built on a clear principle. Settings which provide education on a full-time basis and as a result are more responsible for children's educational well-being should be regulated and subject to government oversight. This measure closes an identified weakness in our existing regime. No more will settings be able to avoid registration and regulation by offering a narrow education, meaning some children not equipped to thrive in the modern world. I therefore propose that clauses 30 and 37 stand part of the bill.
O'Brien.
Thank you, Mr. Chairman. I could potentially pick this up in the next clause 31, but there's an issue that is linked to my concerns about that clause here, and to give the Minister a moment to reply. The Minister mentioned the list of accepted institutions, which we find at clause 30, page 70, line 17. And various types of institutions are exempted: local authority schools, special schools, 16 to 19 academies, FE colleges, YOIs, but not academies and free schools. Why is this? I just wanted to check that this was a conscious choice by the government and try and get an explanation for why that is the case.
Lizzie College.
Thank you, Chair. And with your permission, my remarks apply to clauses 30 to 36. I thought it was more convenient to speak on them all together. Clauses 30 to 36 are extremely welcome to tackle illegal schools. These schools are mostly, but not always, faith-based.
We are debating clauses 30 and 37. Yes, so as long as you stick to that, that's fine. Okay.
I believe my remarks fully apply to clauses 30 and 37, Chair, so if you're happy with that, please do let me know if not.
Very easy go.
Thank you, Chair. The measures to tackle illegal schools, which are often but not always faith-based, are very, very welcome. These measures will protect children from severe harm. The reasons for the need for the measures contained in clauses 30 and 37 are often hidden, and they're often clustered in certain local authorities. The so-called education that takes place in some of these unregistered settings are often deeply intolerant, not aligning with British values and not of good quality for young children. I did have a question for the Minister around the definition of full-time in clause 30. I have a slight concern that we might be creating loopholes. Although clause 36 allows for multiple inspections where there's suspicions that they're linked to part-time settings, I worry that we might be creating a situation where illegal schools could get around the legislation by going part-time. So I just ask the Minister to consider that and perhaps consider, once this legislation is settled in, whether there may be need for action on part-time settings. Now, obviously, we don't want to capture Sunday schools or a bit of prayer study or a bit of, study of the Quran after prayers. But I do think this is something we might need to look at in future. Thank you, Chair.
Minister, do you want to respond?
Thank you, Chair. And I thank the Shadow Minister for his response, the constructive way he is responding to these clauses. He makes a number of points with regards to the clause and whether it will apply to academies. And this clause will not change the way that academies, as state-funded independent schools run by not-profit-making charitable status trusts, as regulated. Academy trusts are accountable to the Secretary of State for Education through their contractual funding agreement, and the terms of which are already require them to comply with the regulatory regime established by the 2008 Act. All academy schools are subject to regular inspection by Ofsted under the Education Inspection Framework.
Is that not also the case already for 16 to 19 academies? I don't really understand why they are having to be exempted here, but non-16 to 19 academies are not. They surely also have the same kind of funding agreements.
I thank the Shadow Minister for that intervention. I'm very happy to take his points away and get him a response in due course.
Thank you.
Chair, I beg to move.
Right. The question is that clause 30 is now part of the bill. As many of our opinions say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 70 to Clause 31, with which it will be convenient to debate Clause 31 stand part. And I call Neil O'Brien to move Amendment 70.
Thank you, Mr. Chairman. This is relatively short and sweet. Our amendment here aims to prevent a large and, I hope, unintentional expansion of the powers of the Secretary of State. Academies and free schools are, of course, independent state-funded schools, and I think under Clause 30, an academy school, though not a 16 to 19 academy, is an independent education institution for the purposes of the 2008 Act. So this amendment to Clause 31 is to ensure that the powers under subsection 1 may not be exercised in relation to an academy, and instead the Secretary of State should instead rely on the provisions in funding agreements as regards to academies and free schools. Now, our amendment is grouped with Clause 31 stand part. And I do want to ask the Minister also something about something I read in the Regulatory Impact Assessment. Page 56 of the Regulatory Impact Assessment says, we have identified one possible adverse distributional impact. Based on our current understanding, the Independent School Standards registration requirements measure is expected to, and I quote, disproportionately impact some religious or faith-based schools. Where in the scope of the new regulation these schools may have to meet the independent school standards, which may entail costs. I wondered if the Minister could say how large these costs are or explain why faith schools are, as the impact assessment says, disproportionately impacted. And this may be unrelated, but I also noted various references in the impact assessments to the Haredim, and I wondered if the Minister could speak to that and why that particular group is affected, particularly by some of these measures and clauses.
Amendment 70 proposed to clause 31 on the amendment paper. The question is, amendment be made? Minister.
Thank you, Chair. I rise to speak to Group 32, which relates to the amendment number 70 in the name of the Honourable Shadow Minister and clause 31 of the bill. Amendment 70. So turning firstly to Amendment 70, tabled by the Shadow Minister. This amendment seeks to disapply the new power to suspend registration found in clause 31 of the bill in the case of academies. I do not think it would be appropriate that the children in academies should not be protected by the additional powers within a regulatory regime that already applies to them. I hope that this gives the assurance sought by the Honourable Shadow Minister and that he agrees to withdraw this amendment. Turning next to clause 31, which makes several changes to the regulatory regime for private schools found in the Education and Skills Act 2008. Clause 31 has a number of distinct parts, including a new power of suspension. It may help members if I quickly summarise the most significant changes. Firstly, this clause will allow the government to set out in regulation standards requiring an individual proprietor or individuals with, for example, the general control and management of proprietor body to be, the Secretary of State's opinion, a fit and proper person. Secondly, this clause allows for the Secretary of State to direct the Chief Inspector to carry out an inspection of an institution which has lodged an appeal against a decision not to register it, so update information can be given to the tribunal. Thirdly, as previously discussed, the clause makes a power for the Secretary of State to suspend the registration and boarding, where applicable, of an independent educational institution, such as a private school, temporarily. This would be where she is satisfied that there are breaches of the relevant standards and she has reasonable cause to believe that, because of the breaches, there is a risk of harm to children at the institution. During the period of suspension, the proprietor would commit a criminal offence if the institution remained open, providing educational or other supervised activity, or if it were to provide boarding accommodation in a breach of a stop boarding requirement. In addition, rights of appeal to the first tier of tribunal are conferred by clause 31(6) against the decisions to suspend registration or impose a stop boarding requirement. It is acknowledged that a suspension of registration would be a very serious step to take and that it would be inevitably disrupt children's education, and for that reason the new powers are likely to be used only in the most serious of cases. It is, however, essential that we have appropriate tools in place that provide the flexibility to act appropriately in cases students are at risk of harm. Fourth, and finally, this clause, by amending section 124 of the 2008 Act, makes changes to how appeals against enforcement action to deregister private schools are to be determined by the first tier tribunal. This is in order to ensure that more effective action can be taken against private schools with long-term or serious failings. Private schools are in some cases able to avoid deregistration by making improvements to meet the standards at the time of appeal hearing. We are making changes to ensure that the first tier tribunal carefully considers future compliance and which reverse the burden of proof so that the appealing proprietor must demonstrate that they have capacity to sustain compliance with the standards. These measures together make many improvements to the existing system of private school registration and regulation, and I therefore recommend that clause 31 stands part of the bill.
Mr. Chairman, we had thought it was unintentional that academies were being brought into this new system of regulation. Clearly from the Minister's comments it's in fact intentional, and this is triple dipping. The Minister already has direct controls over these schools. Clause 43 takes that further, and this is another thing, so I do want to push this to vote, please.
Amendment 70 proposed to clause 31 as on the amendment paper. The question is that the amendment be made. As many of that in say aye. Aye. Contrary, no. No. I think the noes have it. You say aye. Yeah, division. No. Yeah, I've got the message now. It's all right. Aye. Right, division. Division in the room.
Catherine Atkinson.
No.
David Baines.
No.
Matt Bishop.
No.
Ellie Chowns.
No.
Lizzie Collins.
No.
Emma Foodie.
No.
Vicky Foxcroft.
No.
Tom Hayes.
No.
Damien Hines.
Aye.
Catherine McKinnell.
No.
Amanda Martin.
No.
Stephen Morgan.
No.
Neil O'Brien.
Aye.
Darren Paffey.
No.
Ian Solomon.
No vote.
Patrick Spencer.
Aye.
Manira Wilson.
No vote.
So the ayes were 3 and the noes were 12, so the noes have it, unlock. We now come to the question that clause 31 stand part of the bill, which has already been debated. The question is clause 31 stand part of the bill. As many of their opinions say aye. Aye. The contrary, no. I think the ayes have it, the ayes have it. We now come to the question that clause 32 stand part of the bill, with which it will be convenient to debate clause 36 stand part. The question is clause 32 stand part of the bill. Minister?
Thank you, Chair. I rise to speak to Group 33. Group 33 concerns actions which can be taken against those who are operating an education institution in breach of the existing regulatory regime. Group 33 contains clauses 32 and clause 36, but it will also assist the committee if I discuss clause 36 first. Clause 36, existing regulatory regime for private schools, is found mainly in the Education and Skills Act 2008. And this regime requires, among other things, that settings providing full-time education are registered and subject to regular inspection. This allows the government to intervene in cases where children's well-being is at risk. Those not complying with the regulatory regime may be committing a criminal offence and may knowingly be putting children at risk of harm. Ofsted may already investigate and gather evidence of these offences to support criminal prosecution. I'm sure that the committee will agree that if it is vital that Ofsted have the powers that they need to investigate those crimes, and clause 36 grants Ofsted these powers. Let me be clear, these additional powers apply only in limited and specific circumstances. Ofsted's routine activity determining school performance is not impacted by this measure. Instead, these additional powers will only be available when Ofsted is gathering evidence about the commission of the specified relevant offences. This will most likely commonly be in relation to investigations regarding the running of illegal, unregistered school, which is an offence under the 2008 Act. It may help members if I quickly run through each part of the new clause. Section 127A contains the list of relevant offences. It is only during an investigation into whether these offences are being or have been committed, or that evidence of these offences may be found, that these strengthened powers may be used. Section 127B broadens and strengthens Ofsted's existing powers of entry. It sets out that Ofsted may enter any premises without a warrant for the purpose of an inspection. Section 127C provides a mechanism and sets out the process whereby Ofsted may apply to a Justice of Peace for a warrant to enter premises, if it is necessary for the inspection to take place. Section 127D contains a list of strengthened investigation powers which may be used by Ofsted under a warrant issued by the Justice of Peace. Section 127E provides even stronger powers and introduces a mechanism for a police constable to assist with entering and investigating premises using reasonable force if necessary. Finally, Section 127F contains a list of new criminal offences being introduced to discourage those present during an inspection, preventing inspectors from fulfilling their duties in this area. The measures strike the correct balance of ensuring Ofsted can fulfil its statutory function of identifying criminal behaviour in connection with illegal unregistered schools, and so better protect children who may be attending unsafe settings, while providing oversight and scrutiny of the use of the most intrusive powers. Turning now to clause 32. It contains the criminal sentences available against those who are found to be running an unregistered school. Clause 36 will make it easier to identify such people and build a prosecution against them. Those who conducted an unregistered school have demonstrated their unsuitability for future roles overseeing children's education. Clause 32 provides the court with a power to prevent such people from holding this responsibility in future. There are two requirements that must be satisfied before one of these new orders may be issued. First, someone must have been convicted of the offence of running an unregistered private school. Second, the court must consider it appropriate to make an order to protect children from the risk of harm arising from the recipient either again running an unregistered school or by otherwise providing children with education, childcare, instruction or supervision. Provided that these requirements are met, the court has the power to make an order, and it is open to the court to require the recipient to or not to do anything if this is appropriate to protect children from the risk of harm. These orders are needed to prevent and remove dangerous individuals from any role of overseeing a child's educational well-being. Clauses 36 and 32 work together in support of a common goal, better targeting those who are enacting unlawfully are putting children's well-being at risk. These are strong measures, but the need for them is clear and correct safeguards have been built into their use. I therefore hope the committee agrees that these clauses should stand part of the bill.
Lizzie Collins. Sorry, Munira Wilson, sorry, and then Lizzie Collins.
Thank you very much, Chair. It's a pleasure to serve under your chairmanship this morning. I just have a couple of brief questions for the Minister. Sir Martin Oliver, His Majesty's Chief Inspector, raised the question about additional resources for Ofsted because of the administrative burden of applying for warrants. I mean, I think he'd like the powers to go further, that he wouldn't have to apply for a warrant. I can see that there is merit in needing to do so. So could the Minister confirm whether that additional resource will be provided to Ofsted? And with regards to the clauses we are considering in this group, but actually this whole section of the bill on unregistered provision, why is it that alternative provision has been exempted from these powers? Again, Sir Martin Oliver raised concerns that he doesn't have the powers to go in and inspect, or they're regularly finding unsafe provision. And this is an area that we think the government should be taking action on, because some of our most vulnerable children who are excluded from schools are being put in unregistered alternative provision where they're not necessarily provided with a broad education, there aren't always attendance records taken, and there have been real questions and concerns raised about alternative provision. Thank you.
Thank you very much, Chair. I rise to very much welcome the two clauses under debate. The powers of entry, the strengthened powers of entry for Ofsted are very important. And as I said before, a lot of the problems in these illegal schools are often hidden. They're often clustered geographically. So in one local authority, you may never see this problem. And in some local authorities, you will see this problem repeatedly. These illegal settings have been the scenes of widespread neglect and abuse, sometimes serious sexual abuse, and the powers of both entry and the powers for a court to prevent someone who has been convicted of running one of these illegal schools to ever do it again is very, very important. So I would urge the committee to support these clauses. Thank you.
Anybody else wish to speak, or the Minister to respond briefly? Do you wish to respond?
Very happy to. Thank you, Chair. I'd like to rise to speak in response to the Honourable Member for Twickenham's points earlier with regards to Ofsted. With regards to Ofsted, these powers are only available to investigate the commission of specified relevant offences, and it is our experience that the majority of inspections into unregistered schools are conducted to date under Ofsted's existing powers process and on the basis of consent and cooperation. We anticipate that this will continue even after Ofsted has been granted the enhanced powers in the measure. These powers will not be available to Ofsted when inspecting private schools against the independent school standards. She makes a number of points with regards to resources to Ofsted. We are working closely with Ofsted in terms of what the powers will mean, as Sir Martin set out at evidence session at Bill Committee. With regards to the comments made by my honourable friend for Morecambe, I will certainly take those away and write to her on those matters. Thank you, Chair. I beg to move.
The question is that clause 32 stand part of the bill. As many of them opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 71 to clause 33, with which it will be convenient to debate Amendment 72 and clauses 33 and 35 stand part. And I call Neil O'Brien to move Amendment 71.
Mr. Chairman, Section 102 of the 2008 Act requires the proprietor of an academy to make an application to the Secretary of State for approval of a material change. A material change was defined in Section 101 of that 2008 Act. And Clause 33 of this bill introduces a new definition of material change, which adds to the list of material changes contained in the 2008 Act. And in that list, paragraph G requires the notification of the Secretary of State when there is a change of the buildings occupied by the institution and made available for student use. This is at line 12 on page 86. Now, I think some of the things in this list are reasonable things for the school to have to apply to the Secretary of State for if it's a complete change as the proprietor. So change the age range, it stops being a special school, it moves to a completely different location, fine. But the idea that the schools should have to apply to the Secretary of State when there is a change of the buildings occupied by the institution, that is also, it cites me just too vaguely defined. If I build a new building, if I get some new bit stuck on the end of one of the wings of my school, do I have to apply to the Secretary of State? Well, it's not clear on a natural reading of paragraph G. So we worry this would end up with even very minor changes requiring approval from the Secretary of State, which is not necessary, and given that a breach of this provision could lead to an academy being deregistered as an independent educational institution or the imposition of restrictions on the academy, that seems excessive. So our amendments 71 and 72 respectively seek to simply delete paragraph G, which would be the best, which is amendment 72, or at least for the Secretary of State to provide some guidance on it, which is amendment 72. Can the Minister at least provide some reassurance on this point that we're not going to end up with schools feeling like they have to apply to the Secretary of State every time they build a new building, or move out of one wing, or add to an extension to another? It just seems like a recipe for unnecessary bureaucracy, and also creating some legal risks for academies that really shouldn't be there.
Amendment 71 proposed to clause 33 as an amendment. The question is the amendment being made. Minister.
Thank you, Chair. I rise to speak to amendments in Group 34. Amendments 71 and 72. I turn to speak to these in the name of the Shadow Minister for Education. Amendment 71 makes changes to Clause 33 of the Bill. Members will be aware that, among other things, Clause 33 of the Bill will require private schools to seek prior approval from the Secretary of State before occupying a building and making it available for student use. Amendment 37 is intended to remove this new requirement. Now, I appreciate there may be concerns regarding new burdens on private schools, but let me explain why this change is necessary. A change of buildings occupied for students' use, either at or away from the registered address, is not a material change. This means that there is no prior assurance that new buildings are safe for student use. We unfortunately see examples where private schools are inspected and children are found in buildings that are unsuitable for their education and in some cases unsafe. This is important and... Pardon? I will give way.
The Minister keeps talking about private schools, but am I right in thinking this does also apply to academies as well?
I answered the Honourable Member's point earlier on that. We're referring specifically to private schools in this legislation, and this is an important and necessary change, and one which I trust members will support. On Amendment 72, turning to Amendment 72, also tabled by the Shadow Minister, this amendment would place a legal obligation for guidance to be published regarding how a change of buildings for student use will work. I can reassure members that the Department already publishes non-statutory guidance for private schools in relation to applying to make a material change. I can confirm for members that we intend to update this guidance ahead of introduction to explain how provisions are intended to operate. Therefore, for the reasons I've outlined, I would kindly ask Honourable Member to withdraw his amendments. I now turn to Clause 33. If a private school wishes to amend its registered details, prior approval must be sought through a material change application. This process provides assurance that the school will still meet the independent school standards after the change is made. The current regime is too restrictive in the case of schools that admit students with special educational needs. An application for material change is required to start or cease to admit one student. The bill will redefine this material change, requiring an application to be submitted when a school wants to become or ceases to be a special school. It will also become a material change when a special school wants to change the type of special educational needs it caters for. This will provide greater clarity and transparency to parents, commissioners and inspectorates. In addition, as already discussed, there will be an entirely new category of material change. It will become a material change for a school to make a change to the buildings it occupies and makes available for students' use for more than a period of 6 months. This clause also allows for an appropriate degree of discretion in deciding whether a material change can be approved. I will give way.
I thank the Minister for giving way. The National Association of Special Schools have raised concerns that at the moment, when they seek to make material changes, sometimes there are undue bureaucratic delays, which means some students end up losing out on suitable provision. Can the Minister assure them that there will be service level agreements put in place so that these requests can be expedited?
I thank the Honourable Member for that intervention. We are consulting and engaging widely on the bill, and her point has been well made, and certainly the Department will respond in due course on those points. Turning now to clause 35. Finally turning to clause 35. This clause allows more proportionate action to be taken if a private school makes an unapproved material change. Currently, deregistration is the only option available, and to forces a school to close is often not a proportionate action to take. The new proposals will therefore allow for relevant restriction to be imposed by the Secretary of State on a private school when an unapproved material change is made. This will often be a more proportionate response, providing parents with confidence suitable action can be taken to ensure that private schools are safe and suitable. Clauses 33 and 35 make important changes to our material change regime, and I therefore hope the committee agrees that these clauses should stand part of the bill. I will briefly give way.
The Minister is very kind to give way. The Minister keeps using the word private schools, but we're talking about independent educational institutions here, which, as I understand it, includes academy schools, which are state schools. And just to be clear, the Minister keeps talking about proportionality. For the purposes of subsection 2G, even part of a building or a permanent outdoor structure would now require the notification of the Secretary of State. So if you want to build a bike shed, Mr Chairman, you're potentially having to go to the Secretary of State. The Minister talks about proportionality. This does not seem proportionate at all. Perhaps he can answer that point.
I thank the Shadow Minister for his intervention and want to assure him it does apply to academies. So thank him for raising that point. So clauses 33 and 35 make important changes to our material change regime, and I therefore hope the committee agrees that these clauses should stand part of the bill.
Mr Chairman, sorry, I really do wish to push this to the vote. The Minister has confirmed that this does apply to academy schools. It is not, in the words of the Minister, proportionate to require the Secretary of State to have to be informed when a state school builds part of a building or a permanent outdoor structure. You put up a gazebo, you have to go to the Secretary of State. This is not proportionate. It's an error in what's been put here. The rest of this is totally reasonable, but I do want to move this amendment because I think this point here is just unreasonable.
Amendment 71 proposed to clause 33 as an amendment. Paper the question is the amendment be made. As many as that didn't say aye. Aye. The contrary, no. No. Division.
Division in room 10.
Catherine Atkinson.
No.
David Baines. No. Matt Bishop.
No.
Ellie Chowns.
Yes.
Lizzie Collins.
No.
Emma Foodie.
No.
Vicky Foxcroft.
No.
Tom Hayes.
No.
Damien Hines.
Aye.
Catherine McKinnell.
No.
Amanda Martin.
No.
Stephen Morgan.
No.
Neil O'Brien.
Aye.
Darren Paffy.
No.
Ian Sollum.
Aye.
Patrick Spencer.
Aye.
Manira Wilson.
The ayes were 6, the noes were 11, so the noes have it, unlocked. Keep going. All right. We now come to the question that clause 33 stand part of the bill, which has been debated. The question is that clause 33 stand part of the bill. As many of our opinions say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 34 stand part of the bill. The question is that clause 34 stand part of the bill. Minister.
Thank you, Chair. I turn to Group 35, which relates to Clause 34. This clause removes an ambiguity in the Education and Skills Act 2008 as to when a private school or other independent educational institution may be permanently removed from the register. Section 100, which this clause amends, currently allows for removal in certain circumstances, but is silent as to whether an institution can be removed with the proprietor's consent only. The new power therefore expressly allows the Secretary of State to remove a private school from the register immediately, where a proprietor requests or agrees in writing that this should be the case. This provides not only for administrative convenience, but also public benefit to allow for the register to be quickly updated and kept accurate where the proprietor is consenting in writing to removal. I therefore hope that the committee agrees that this clause should stand part of the bill.
Anybody wish to speak? No. The question is that clause 34 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 35 stand part of the bill, which has already been debated. With the leave of the committee, I will put the question that clause 35, 36, 37, which have also been debated, stand part of the bill. The question is that clause 35, 36, 37 stand part of the bill. May that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 38 stand part of the bill. The question is that clause 38 stand part of the bill. Minister.
Thank you, Chair. Private schools are subject to inspection to ensure that the education that they offer is safe and helps children achieve and thrive. In addition, where a school provides accommodation, it is also subject to welfare inspections to ensure that it is complying with its duty to safeguard and promote the welfare of its boarding children. Around half of all private schools are inspected by the Independent Schools Inspectorate, with the remainder inspected by Ofsted. This clause is intended to strengthen the relationship between these two inspectorates to facilitate high-quality inspections and the identification of safeguarding risks. It would also ensure smooth working between Ofsted and any other person that may be appointed to inspect a registered setting under Education and Skills Act 2008 or appointed to inspection accommodation provided to children by a school or college under the Children Act 1989. There is a clear interest in inspectorates working closely together, willingly collaborating on best practice and ensuring that known safeguarding risks are shared and acted upon. This clause makes two types of changes to support these goals. The first type of change amends existing statutory obligations on the Chief Inspector to report at least annually on the quality of other inspectorates. This obligation will be replaced with a more flexible obligation on the Chief Inspector to report as and when required and on all aspects of an inspectorate's performance, or only some. The second change confers two new express powers on the Chief Inspector to share information with the other inspectorates for the purpose of enabling or facilitating their inspections. This change removes any ambiguity on whether the Chief Inspector may share information directly with other inspectorates for these purposes. This information can already be shared via the department. This change will allow the freer flow of information between the inspectorates and facilitate closer and joint working for the purpose of keeping children safe. While minor, these changes will support even closer working between the inspectorates, leading to better outcomes for children, and for that reason, I hope the committee agrees that the clause should stand part of the bill.
Any comment? The question is that clause 38 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 39 stand part of the bill. The question is that clause 39 stand part of the bill. Minister.
Thank you, Chair. This government takes very seriously the protection of children and young people, particularly when they're receiving their education. And we know that teachers are the single most important in-school factor in a child's education. And we also know that the overwhelming majority of those teachers are highly competent and never engage in any form of serious misconduct. But the reality is that some teachers do commit serious misconduct, and it's vital that when this occurs, it's dealt with fairly and transparently. And this is why we have robust arrangements in place for regulating the teaching profession. The overriding aims of the teacher misconduct regime are to protect children and young people, to help maintain public confidence in the teaching profession, and to uphold proper standards of conduct. This reflects expectations placed on teachers throughout their career, both in and outside of the school, as set out in the published teacher standards. The current teacher misconduct regime has been in place since 2012. Since then, we've made a number of changes to the processes and procedures to take account of relevant case law and High Court judgments. This includes changes we made to the publicly available teacher misconduct advice, which considers the factors to be considered by professional conduct panels when considering cases of teacher misconduct. We've also amended the funding agreements of further education colleges, special post-16 institutions and independent training providers, so that, like schools and sixth form colleges, they do not employ prohibited teachers. But there is more that we need to do to ensure children and young people are protected, and the only way we can do this is to make the amendments proposed by this clause. This clause will allow the Secretary of State to consider whether it is appropriate to investigate serious misconduct that occurred when the person was not employed in teaching work. But we will ensure that cases are only taken forward where there is a clear rationale for doing so, that a range of factors have been considered, including public interest, the seriousness of the misconduct, and any mitigation presented by the individual. This clause will also extend the teacher misconduct regime beyond schools and sixth form colleges to cover further education colleges, special post-16 institutions, independent training providers, online education providers, and independent educational institutions. This will ensure that children under the age of 19 are protected, whether they may be accessing their education. And finally, it will enable the Secretary of State to consider referrals of serious misconduct irrespective of where they come from. At the moment, legislation does not allow the Teaching Regulation Agency to consider referrals from departmental officials where serious misconduct comes to their attention during the day-to-day duties. This clause may ensure that cases can be referred to the Teaching Regulation Agency promptly without the need to wait for a third party to make a referral, or where it is unclear whether someone else has made or will make the referral. But we are also very clear that this should be a fair and transparent process, and we will provide training for staff to help them understand more about the types of circumstances in which they should consider making a referral. Collectively, and most importantly, this clause will ensure the protection and safeguarding of more children and young people. I therefore, Chair, recommend that these clauses should stand part of the bill.
David Hunt.
Thank you very much, Sir Edward. And I want first, if I may, ask the government front bench just a little bit about process. Obviously, in Parliament, when we ask questions, quite often they are rhetorical questions. We don't expect answers on those from ministers, and we don't get those answers. But this is committee stage of a bill. It is known as line-by-line scrutiny, and quite often the questions we put are questions of facts or of intent of the legislation. I've asked a number of questions in different stages of this committee stage which haven't been answered. Now, the Minister has not been saying necessarily, I will write to the member in response. I just wanted to check with ministers if they are intending to do that, or if there are any questions that have been kind of left hanging, if that requires us to put down a written parliamentary question, perhaps the Minister would respond. For the avoidance of doubt, what I'm about to say is not in that category of question that would require a factual response or note of intent. But on clause 39, on the misconduct regime, I mean, clearly this is exceptionally important for the protection of children, for public confidence, and for maintaining the very highest reputation of the profession. And what is new in this clause, I welcome, I think is right and proportionate. So being able to take action regardless of when the incident took place and whether the individual was a teacher in the profession or not at that time, bringing into scope online education, independent educational settings, and being able to investigate a suspicion, an incident, regardless of how it came to light. All of those things, I think, are welcome. I wanted to ask the Minister about something related, though, to the regulatory regime, which is not something that would technically require primary legislation, but there are quite a lot of things in this bill which don't actually require to be in primary legislation. And that is the matter of vexatious complaints. So in the world in which we live, and particularly with the influence and the prevalence of social media, there is a feeling, and you hear it from teachers, that sometimes, it's a small minority of cases, but complaints may be made against a teacher for not the right reasons, and not because there is a genuine safeguarding concern. And of course, there shouldn't be barriers towards people putting concerns. Whatever their background, it should be available to everybody. But equally, I think there is a concern sometimes that you can make something, to choose my words carefully, but in seeking to remove barriers, you don't want to go too far the other way, and make sure that there is a process to go through so that all genuine concerns and complaints do come through, but that we don't end up with an excessive volume of vexatious complaints, and as I say, fuelled, I'm afraid, these days sometimes by social media.
Thank you very much, Chair. Can I just put on record, I have not met a single teacher who has not received some form of vexatious complaint at one point in their career. It's something that I hope the Minister does speak to. This bill expands the scope of potential dismissal. In my experience, a dismissal process is incredibly cumbersome and costly for schools. And I was wondering if the Minister could speak to what provisions he's going to make for schools to be reimbursed for what they're going through. And the last point I'd like to make is... I can't read my notes. Yes. It expands the capacity to look back into a previous career of someone who started up a school. Would, for instance, a bankruptcy prevent someone from being considered worthy of running a school? And I wonder if the Minister can speak to that, whether kind of a perfectly reasonable kind of business experience might cause the Secretary of State to intervene on this moment.
Thank you, Chair. I appreciate the questions and contributions from the opposition on this important clause. The Right Honourable Member is right to make sure that he gets responses to all the questions that he raises. I know he's not shy in submitting written parliamentary questions from my own postbag in responding, so I know that he will find that route or any other appropriate route. And obviously, he's asked a number of detailed questions. I'm very keen to make sure that we are scrutinised in the way that we are taking this bill forward. If there isn't anything that we've responded to, then I'd obviously be delighted to do so. With regards to...
To give a couple of examples, the distinction between elective home education and education otherwise than at school, or what happens with optional uniform items, or what happens to schools that already have a breakfast club which lasts longer than 30 minutes. None of these is meant to be a difficult or rhetorical catch the minister out question. They are genuine questions. I don't think any of those we had answered on the floor of the committee. My question is just, is he going to write? Are they going to write in general? Or do we need to put down further questions if we want to get answers to these?
I thank the Right Honourable Member for that intervention, and his questions will be on the public record, and we will do our best to respond to each of the points that he made. I don't know if my colleague also wants to respond.
Yeah, in order to seek clarity for how the committee is conducting itself, the Right Honourable Gentleman has said a number of times in his speeches, and in addition, the Honourable, the gentleman, the front bench spokesperson, we appreciate we are asking a large number of questions, and we do not expect answers to all of them. That has been said a number of times in this committee.
Not now.
Excuse me, I'm speaking. And we'd be more than happy to answer all of the questions that are being asked, but it may be helpful if the Honourable Gentleman and his colleague were more clear specifically about which questions, if they do require specific answers, whilst we're discussing the specific clause that have not been answered, we're more than happy to furnish them with responses.
I mean, Order, the general practice is that people put questions and the Minister attempts to reply to every question. If an opposition member feels that the Minister has not replied to the question, he can object. You can speak as often as you like, or you can indeed request the Minister writes to that member, and the Minister can agree to that or not. But the whole purpose of this committee is for people to ask questions, and the Minister do his level best with the help of his excellent officials to answer every question, which these excellent ministers will, of course, do.
Thank you, Chair. That's very kind of you, and absolutely agree with what you've just said. So the Right Honourable Member obviously made a number of points with regards to the Teaching Regulation Agency. He will know from his time as the Education Secretary that they do not deal with complaints, and it only considers allegations, the most serious misconduct, any complaint which has been incorrectly referred to it will now undergo an initial triage process, and this will determine whether a referral should be progressed by the Teaching Regulation Agency or whether it is more appropriate to redirect a complainant to another service. The member for... thank you. Kindly asked the question around reimbursement. The answer simply is no, but more broadly on the new burdens placed on these settings will be a requirement to understand the regime and the duty to consider whether making a referral to the Teaching Regulation Agency where a teacher is dismissed for serious misconduct or would have been dismissed if the teacher hadn't resigned first. We will engage with stakeholders to ensure that they understand what they are trying to achieve, and once the bill receives royal assent, we will explain the changes to the setting affected and how they can manage these. Happy to give way.
Does the Minister expect the number of situations in which there is a misconduct hearing and the number of teachers who are brought forward for potential dismissal to increase considerably? Because I'm concerned that you're going to see the consequences of this bill will be huge for many schools, and they are going to be burdened with a huge cost. Does he expect the numbers to go up?
I thank him for his intervention. We obviously consider these matters extremely closely as we progress the bill further, and certainly I would take that point away to officials. With regards to the point around bankruptcy, the Teaching Regulation Agency only considers allegations of the most serious cases of misconduct. Cases of misconduct are not serious enough to warrant a lifetime prohibition from teaching, and all cases of incompetence are more appropriately dealt with by employers at a local level. Chair, I beg to move.
The question is that clause 39 stand part of the bill. As many of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 73 to clause 40, with which it will be convened to debate Amendments 74, 75, 76 and 94 and clause 40 stand part of the bill. I call Neil O'Brien to move Amendment 73.
Thank you, Mr. Chairman. Sir Martin Oliver gave us a very good example of how these current freedoms are used. On our very first day in this Bill Committee, he said, in the past I brought in professional sports people to teach alongside PE teachers, and they had run sessions. Because I was in Wakefield, it was rugby league. I had rugby league professionals working with about a quarter of the schools in Wakefield at one point. And when he said that, I thought about how much we would have loved, when I was being taught rugby league not far away in Huddersfield, how much we would have loved it if the people had come up from Fartown, the professionals, to teach us. We were actually never, ever told what the rules of rugby league were, nor was it revealed to us that it was a different type of rugby. And it would have been amazing to have the professionals with us. And that's just one example of how schools use non-QTS teachers in a brilliant way to bring in people who otherwise would never be in state schools. And former head teacher David Thomas told us the same thing. I have concerns about limiting the number of people with unqualified teacher status who are not working towards qualified teacher status. He said, I have worked with some fantastic people, generally late career people in shortage subjects who want to go and give back in the last 5 to 10 years of their career, who would not go through some of the bureaucracy involved with getting qualified teacher status, but absolutely fantastic and have brought wonderful things to a school and to a sector, and I have seen them change children's lives. And Rebecca Leake from the Suffolk Head Teachers Association gave another good example. She told us, I had to step in as an interim head teacher in Ipswich just prior to COVID. I did not have an early years lead. There was someone who was not a qualified teacher but who had been running an outstanding nursery. I took her on, and although she was not qualified, she really was excellent. I was able to do that because it was an academy school and it was not an issue. In a maintained school, if there's a specific need for qualified teachers to teach early years, I would not have been able to take her on. And likewise, when I asked Julie McCulloch from Askell whether it was better to have a non-QTS teacher than no teacher, she noted that sometimes that is the case, particularly when we're looking at vocational subjects at the top end of secondary school and into colleges. And indeed, when the Secretary of State was asked about this on the newsagent last night, she made exactly the same point as well. And indeed, the government's own impact assessment to this bill says of this measure that, and I quote, some schools may struggle to find the teachers that they need as a result of it. And it says that from September 2026, we estimate that this could affect around 700 to 1,250 potential entrants into the teaching profession per annum. This represents 1 to 2% of all entrants into the teaching workforce in 2022. The only thing I would take issue with that in that sentence is into the teaching profession, because it's not the teaching profession as a whole, it's only state schools that these potentially brilliant teachers will be locked out of, not private schools. They won't have the same burden put on them. And the impact assessment says, in attempting to construct an argument for this restriction, evidence suggests that being taught by a high-quality teacher can add almost half a GCSE grade per subject to a pupil's results. Obviously, too, we all know that high-quality teachers are the key thing in education. But amazingly, DFE does not then go on to produce a single shred of evidence, not even an attempt, not even one tiny particle of evidence, that teachers without QTS are of low quality. And when the minister's been pressed on this, they don't demur from this point. So a policy is being adopted here without any evidence at all, nor is there any estimate of what impact the creation of a new barrier to entry might have, particularly in the sorts of subject areas that QTS teachers are employed in, which are often those that are more difficult to recruit in. And even the government sort of acknowledges this is not needed. A footnote, we find this out by reading a footnote on the bottom of page 24 of an impact assessment that was published halfway through the bill committee process. I mean, it really is like the Hitchhiker's Guide to the Galaxy. You know, the plans are available if you go to a locked toilet in an abandoned room on the bottom floor of a building that's open twice a year. On the bottom of a footnote, on the bottom of page 24, it is revealed that unqualified teachers will not require QTS to work in further education, 14 to 19, and 16 to 19 academies, in university technical colleges, in studio schools, and in non-maintained school early years settings. So one first question to the Minister is, if it is so desperately important to ban non-QTS teachers from our school, so important that we have to take primary legislation to do it, why are all these other types of schools not included? How many QTS teachers, non-QTS teachers rather, are in these settings and so will be exempt? Now, last month data came out showing that the government had only recruited 62% of their target number of students into initial teacher training for secondary schools, with particularly dramatic shortfalls in subjects like physics, where it's just 30% of the target, in business studies, D&T, music, computing, and chemistry. And the NEU rightly talks about a global teacher recruitment and retention crisis. And most school systems across the world are battling to try and recruit teachers. Mr. Chairman, if you simply Google teacher shortage Ireland or teacher shortage Australia or pretty much anywhere, you will see what I mean. Now, between 2011 and 2023, the last government added 29,454 extra teachers to schools in England, and it grew the total school workforce by 96,555, or 11%. That's the addition, just to be completely clear. And yet we still have a shortage of teachers in key subjects. Now, about 3% of teachers are non-QTS. So this might seem like a very, very odd time to make things harder for schools to recruiting good teachers, particularly in those specialist subjects that they tend to be used in. And to that end, our amendments seek to at least limit these counterproductive new restrictions, which have received a wide variety of criticism from the sector. Amendment 73 puts in a 5-year grace period, and not requiring QTS can get teachers through the door into state education. And what message does it send to those people who are mid-career, who might want to become teachers, might want to give back, but they can't actually afford to do a PGCSE or an apprenticeship? Amendment 74 allows mobility. At present, the government's plan will grandfather non-QTS teachers, but if they move school, they will have to get QTS, and our Amendment 74 fixes that. Our Amendment 75 retains the freedom at least for shortage subjects. Amendment 94, in the name of the member for Twickenham, also looks at that exact issue too. And our Amendment 76 allows academies to maintain discretion about whether to employ teachers without QTS if they are subject matter experts and have received training from the academy in question. But the bottom line is, Mr. Chairman, where is the evidence? Where is any evidence that this is a problem in our education system, never mind one of the most important problems, never mind something we need to take primary legislation? And where is the evidence that DFE ministers know better who to employ than the school leaders themselves? They haven't produced a single shred of evidence in the impact assessment. And I'm afraid this is just another example where ministers seem to believe they know best. It will make recruitment charges harder, create a barrier to entry into state schools, and will stop some great sports people, IT people, people who want to give back from doing so. Now, the unions, just to complete this one sentence before I give way, the unions, they want this. They have for years, but it remains a mistake. I will give way.
The honourable member has twice referred to professional sports people and raised at the very beginning that this was quoted alongside teachers. Would the honourable member acknowledge that there is no prohibition on professional sports people or on other experienced, inspiring professionals being able to contribute alongside teachers? The issue is when they do so without that input, and I would kindly invite the honourable member to correct that position.
Well, no, the honourable lady has completely missed the point. If we pass this clause, schools will not, academy schools, will no longer be able to employ people without QTS to do exactly the kind of inspiring things that Sir Martin said he had used them so brilliantly to do at the start of our first evidence session. I'm happy to give way.
Said, and the quote was, alongside teachers. It is not prohibited to have people there alongside teachers. And I'm sure that the Minister will clarify if I'm mistaken in that matter.
To be clear, it will be illegal to employ them if they don't have QTS. You can have people turn up, but you can't employ them anymore. I don't know whether the member is deliberately trying to muddy the water or whether she's just missed the point. The ministers haven't chosen to intervene on this point, I notice. But let's be clear, this clause will stop Sir Martin and people like him from doing exactly what he said he had found it useful to do, and employing non-QTS teachers, alongside teachers, but employing them to come and deliver and to give back to their community. So, Mr. Chairman, I see nobody during the course of my remarks has stood up to offer me a single shred of evidence that QTS teachers are bad teachers and that they are somehow a big problem in our schools and that they are one of the top problems that we need to be addressing in the system. This clause will make things harder for schools. It will mean fewer pupils get a good lesson if ministers pass it. Our amendments aim to stop this piece of vandalism, which is something the unions wanted, something ministers have given them, and something that will be bad for our schools and bad for our children.
Yeah. Amanda Martin.
Thank you, Chair. I feel compelled to speak on this, and you talked, the Honourable Member talked around bottom lines and around evidence. We are at the moment, the gap is widening, much wider, the attainment gap is widening across our country with regards to those that achieve and those that don't achieve. For a number of years, and since the previous government, and the Right Honourable Member from East Hampshire was in fact a defence, not at the moment, no. The Right Honourable Member, the gap is widening. The attainment gap has widened.
Does the Honourable Lady know what the attainment gap was at Key Stage 2 and Key Stage 4 in 2010, how that compares to right now?
I'm not going to... Pardon? No. As the Right Honourable Member knows himself, he was actually a Secretary of State, and over his time as Secretary of State, the teacher shortening crisis was worse than it had ever been under his leadership. Recruitment targets for core subjects such as maths, physics, modern languages were missed, and retention rates were very poor. This was in a realm of when we were allowing people with qualified teacher status and unqualified teacher status. It is not a bottom line around what we are wanting our children to have. It is actually should be a right for every single child, wherever they are in the country, to be taught by a qualified teacher or somebody en route to a qualified teacher status. And just because we haven't achieved it under the last government doesn't mean we shouldn't have ambition for our children to achieve it under this government.
Thank you very much, Chair. I note your comments earlier about speaking specifically to the clause that we're considering and the amendments in this group. I just wanted to start with some comments that relate to both this group but also several clauses that follow, so that I don't try the committee's patience by repeating myself on each one. That's in general with regards to the various academy freedoms that we are considering several clauses on over today in this bill. I just wanted to take a step back and ask the question, where have these proposals come from? The entire sector, and indeed the Children's Commissioner, seem to have been blindsided. And when I speak to teachers and school leaders, top of their priority list are sorting out SEND, the recruitment and retention crisis, children missing from school and children's mental health. And parents tell me they just want their schools funded properly so that they're not being asked to buy glue sticks and tissue boxes. Not once have I either heard a maintained or academy school leader or parent say to me that actually the biggest problem in our schools that we need to sort out the academy freedoms. And this was reflected in the oral evidence that we heard. To quote Sir Dan Moynihan, it is not clear what problem this is solving. I've seen no evidence to suggest that academy freedoms are creating an issue anywhere. Why are we doing this? So I asked ministers that very question. What is the problem they were seeking to fix when they drew up this clause and several subsequent clauses in relation to the academy freedoms which they are trying to diminish? Now, specifically on qualified teacher status that we're considering in clause 40, of course, we all want to see qualified teachers educating our children. We know that excellent teachers are a key factor in good educational outcomes for children. But looking at the Department for Education's own data cited in the House of Commons Library report on this bill, in November 2023, academies employed marginally fewer qualified teachers compared to maintained schools. The DFE's own stats tell us 97.4% of full-time equivalent teachers in primary academies had QTS, compared to 98.4% in maintained primary schools, and 96.5% of FTEs teachers in secondary academies had QTS, compared to 97.3% in maintained secondary schools. I'm actually reassured, Chair, by those figures that so many teachers in front of our children are qualified. Obviously, we'd love it to be 100%, but there are good reasons that we can't necessarily reach that number. Now, I would just say gently to Conservative colleagues on this committee, let's not forget, it was them that repeatedly failed year after year to meet their teacher training targets when they were in government, not least in maths and science, where we see some of the biggest shortages. So I don't really feel they're in a position to preach on this subject, given how little they did to address the teacher recruitment and retention crisis. And we heard from the Association of School and College Leaders that a number of schools rely on experts in their field, particularly for technical and vocational subjects at the top end of secondary school and into colleges. And Julie McCulloch said to us in her evidence, there are some excellent teachers and lecturers in further education colleges and secondary schools on vocational subjects who do not necessarily have qualified teacher status. So I say to ministers, we're talking about a small number of unqualified teachers, and some of those experts may not want to train as teachers. Now, are ministers really saying that they would rather that pupils go without a teacher? I know from talking to some local schools in my own constituencies, they've really struggled to fill vacancies in design and technology and in computer science. I mean, it's ironic. I have a brilliant, outstanding secondary school in my constituency called Turing House, and for a while they had to take A-level computer science. Turing House had to take computer science off the curriculum because they couldn't find a computer science teacher. So are we saying that if some design expert wanted to come and do DT in a school, or teach DT in a school, or an IT guru wanted to offer their services, should we really turn them down and those children miss out on studying those subjects? And that's why Amendment 94 in my name requires the Secretary of State to take account of the availability of qualified teachers in each subject and the desirability of specific sectoral expertise when making regulations under Clause 40, because we agree, ideally we want every child taught by a qualified teacher, but we have got to recognise that in the world we are living in, and given the shortages, that there will be times when actually the best thing for a school, for a child, and for teachers is for other school staff is to see potentially experts coming in who don't have a teacher qualification. So I hope that ministers will support this modest amendment in order to prevent unintended consequences. Thank you, Chair.
Darren Paffy.
Thank you, Mr. Edward, and it's a pleasure to serve under your chairship. I rise to support Clause 40 and to argue that the amendments under discussion are unnecessary. I very much welcome this measure. It underpins the ambition that the government has got to ensure that every child gets the best quality education. And while this will not necessarily be a shared view, actually the top quality of education comes through not obsessing about structures, but about getting the right people in place. So this is simply a common sense proposal to ensure that across the board, no matter what the structure of the school, parents can be reassured, and as children set foot in that school, they can be reassured that they are getting the best quality education. I'll make some progress and then be happy to give way. I would point out and would ask opposition members to reflect on the logical fallacy, really, of applying this laissez-faire approach in a way that they probably would not do, or at least I hope they would not do, for other professions. I think it's uncontroversial to ask for assurance that when I take my car in for repair, I'm not just doing it, giving it over to someone who's enthusiastic about car repairs, but they're actually qualified. The stakes of that going wrong are high. Someone who doesn't know how to fix brakes is going to cause significant risk. When I visit the GP, I want the reassurance that I've not just got someone who's done health tech and has got a great 20-year-long career in that and has decided to swap over and offer their expertise in there. I want someone who's absolutely qualified in that practice. And so suggesting that subject expertise alone is enough, and actually I would reiterate what my honourable friend, the member for Derby North, has said. No one doubts the quality of subject experts. No one doubts that those with significant top quality experience can come in and be absolutely inspirational. But by suggesting, however, that that is enough, they do suggest then that qualified teacher status adds no value to that subject expertise. What about the skills in effective student development, pedagogy, collaboration, class management, assessment and feedback, differentiation? These are not things that come naturally with subject expertise. Who's diving in first? I'll give way.
Honourable Member, thank you for giving way. If you take a moment later today and listen to the Secretary of State's interview on the Newsagents podcast, Emily Maitlis said, you can have a terrible teacher with qualified status, but a fantastic teacher who is not qualified, can't you? And the Secretary of State's response was, absolutely. Does he agree with her, or does he disagree with her at that point?
What I agree is that if someone is not performing up to scratch, then the response is not to remove the qualification for everyone else. It's to deal with that individual teacher and drive up standards within the school. That is, once again, completely common sense. I will give way.
Thank you for giving way. Does my honourable friend agree that we train our teachers for a reason? And would my honourable friend agree that parents expect their children to be taught by qualified teachers for a reason? And would my honourable friend agree that some of the dismissive attitudes that we have heard from opposition members are insulting to the professionalism of our qualified teachers?
I would fully agree that it is deeply concerning that qualified teacher status is so unimportant to them. I would say, however, it's unsurprising that the profession is in the state it is and feeling utterly undervalued after the last 14 years. I simply do not understand why qualified teacher status in all schools is such a low priority for some. Honourable member opposite mentioned that it is the prerogative of good head teachers to have that freedom. Would he therefore logically suggest that it's the freedom of every hospital director to decide whether someone is suitably qualified to carry out surgery, or would they ask for an independent, agreed, common framework of training and qualification for surgeons? I suspect and I hope it would be that. So the response, as I've said, to the recruitment and the shortage issue is not, therefore, to lower our ambitions. I would think back to the evidence session from which we heard from Sir Martin Oliver, His Majesty's Chief Inspector of Ofsted. What he actually said is that appointing a non-qualified teacher to role was a deficit decision. His words, not mine. He said that it was not his first choice, no matter how well it worked, and that non-QTS staff should supplement fully qualified staff not replace them. And I ask the opposition to reflect on that, because what this proportionate, reassuring measure is doing is restoring common sense. It is once again restoring the value of teaching as a profession, alongside the other measures that have been taken that certainly weren't taken over recent years on teacher pay, teacher prestige and investment in schools.
David Hines.
Thank you very much, sir. It's a pleasure to follow the honourable gentleman for Southampton. I enjoyed his speech, and I think he made a number of very good points, a number of which we would agree with. Certainly the importance of the foundation of qualified teacher status, and you know, a lot of work rightly went into reforming the core content framework, initial teacher training, and indeed the early career framework. And these are very, very important, incredibly important foundations for a successful career in teaching. Look, the present government, with the slowdown they're doing in recruitment to just 6,500 that they plan to add over the next 5 years, a material slowdown compared to the Parliament just ended, it should be more straightforward to hit those recruitment targets. And I don't think this discussion today is really about the numbers you can recruit into the teaching profession. It is about getting the right people. And he said that too. It's about not obsessing about structures, it's about the right people. And this is about getting the right people in front of children in school settings, which, by the way, doesn't just mean, because we're not talking just about academic stuff, it's also talking about sport and music and arts. And actually the value, I'll happily give way.
Well, can you all remember, answer me this question, which is better? An English graduate with QTS teaching maths in a secondary or primary school, or a maths graduate that's not QTS teaching maths in a primary or secondary school?
Well, look, I think this is where the whole house comes together. The best of all worlds is to have someone who is both a subject specialist with an excellent, their own excellent academic record, and QTS, and to be a really inspirational practitioner. These three things do come together, of course, on many, many occasions, but there are choices that have to be, sometimes choices that have to be made. And particularly...
Just to say that, would he not agree, therefore, that the right people that we're talking about are not just those who, quite rightly, often do have a stellar career in another area of subject expertise, but would they not be right for children and for schools if they not only wanted to bring that expertise, but do everything they can to be best prepared to direct the curriculum and the outcome and the chances of those children by being qualified?
Of course. And for many people that's the right thing to do, and there are mid-career or later career programmes for coming into teaching. I want people to do that more and more. Sometimes though people come from abroad, where it's from a country where we don't necessarily have mutual recognition, or they might come from the independent sector. They might have taught for many years, actually, and be an outstanding practitioner. Or, and he said, if he went to the mechanic and was just like fascinated by engines, well, I understand that entirely. But you know, if you wanted to learn football and you had the opportunity to learn from a professional footballer, not as the only PE teacher. Oh, look at this. How do I choose? I'm going to go to the Honourable Lady from Portsmouth.
Thank you very much for the cracking football team, I will add. Absolutely, those sports, men and women, can inspire, but actually many of those at the elite of their game would not have understood the difficulties of those children that maybe not be as good at that sport, and therefore the learning of pedagogy and differentiation and those kind of things. So they could absolutely enhance learning, but actually becoming a teacher would need a qualified teacher status in order, if you're really committed and you want to give something back, a PGCE in your time of the year, having that online, on-the-job training, we should not be racing to the bottom with our kids.
Well, I'm very happy to let that comment sit there, because of course she's right. Of course, there are many things that come from a PGCE, but being a top 5 footballer may not be one of them. And as that kid, actually having in your school other PE teachers, as I say, as well, but also somebody with personal experience of playing at a high or even a high-ish level. That might really bring something. And that doesn't negate the point that the Honourable Lady meant, but it also, I think, stands on its own. The Honourable Lady.
I thank the Honourable Member for giving way. As the parent of a former footballer, I know that the FA doesn't let people coach football, even on Saturday League, without being a qualified coach. And so his analogy falls down because...
She makes my point for me.
No, I make my point, which is that it's entirely reasonable to require that people who are in an educational role are qualified to take that role, either qualified already or undergoing the process of qualification. And if somebody wants to be a teacher and wants to contribute to educating our young people, I see no reason why they would not want to make sure that they have the skills to do that. I let you finish your sentence.
I think she makes my point for me. But actually it is possible to engage in the training of children learning football without PGCE. Because...
Under the
because...
Will the Honourable Member give way?
Yes.
When coaching young people playing football,
Yes.
the Football Association is the relevant regulatory body.
Yes.
When coaching Saturday clubs.
Yes.
When teaching in a school,
Yes.
the relevant regulatory body is that which gives qualified teacher status.
Yes, but that doesn't change the fact that individuals, perhaps including your son, I don't know your son, I don't know his circumstances or his school career, may be perfectly capable of helping kids learn how to play football without having done a PGC. And this happens, colleagues and friends, and this happens all the time. And it happens, by the way, it happens, forgive me, in clubs and in schools. So you will have after-school football clubs, you will have before-school football clubs, and if the thing starts 5 minutes after 3:30 or finishes 5 minutes before 3:30, I'm not quite sure I understand how that individual's ability to help kids learn how to play football is materially affected. I didn't realise we were going to spend today talking about football, Sir Edward. I will have on the Honourable Lady.
The right honourable gentleman's been way. I think it might be helpful to clarify, although I'm surprised it needs clarified for a former Secretary of State for Education, that the current exemptions for qualified teacher status, he will be well aware of them. They already apply to maintain schools, and they will continue to apply as part of the extension of the same requirements to the academy system. So he will be well aware of the exemptions, and he will be well aware that what he is saying is not correct.
No. He may be well aware of many things, but he's certainly not well aware that what he's saying is not correct. He is totally aware that what he's just said is correct. That people who do not have a PGC, do not have QTS, may still form a valuable and useful part of the staff at a school to help kids learn in a variety of disciplines, including non-academic ones, such as sport and art. I'm starting to attract a little bit too much attention from the chairman, who I think may be becoming impatient with me for that, but I will give way one last time.
I thank the right honourable gentleman for giving way and for his patience with our multiple interventions. However, I believe they're very necessary. Would the right honourable gentleman agree with me that the experience of hundreds of thousands of parents during COVID lockdowns when schools were closed show very clearly that having professional knowledge, having experience in the workplace is no substitution for being a teacher? As someone who homeschooled a 2-year-old and a 6-year-old, trust me when I say that experience gave me even more respect for the qualified teachers in this world. So would the honourable gentleman agree that there is a fundamental difference between subject matter expertise and the ability to teach?
I agree with her 100%, Mr. Edwards. Just as I agreed with her honourable friend entirely in what he said. Of course, there is not just a material difference between not being a qualified teacher and being a qualified teacher. It is like night and day. And what you learn about the pedagogy and the experience you get during that time is cannot be replicated on an online course or by reading books. Of course, and she is also quite right, that during COVID, I think quite rightly, millions of people up and down the country developed or renewed or enhanced the respect that they had rightly for the teaching profession and what teaching is capable of doing. I did say one last time, but I can't refuse my honourable friend.
I thank my honourable friend for this. On this point about respect, I completely agree with my honourable friend saying and the respect we do to teachers. One of the honourable members opposite talked about a race to the bottom. And yet that's not what the Secretary of State is saying. And there's no evidence in any of what the government's doing that there is a problem with the quality of non-QTS teachers. Indeed, we heard from Rebecca Leake at the start of our Bill Committee sessions that it was a race to the top. She was getting one of the best people, and she happened to be running a nursery. She hadn't gone into teaching, but she knew all about the early. She was one of the best people we could possibly get, even though she was non-QTS. And another honourable member in this Bill Committee said, there's no reason you wouldn't get QTS. Well, actually, in lots of cases, there are reasons. Maybe at the very end of your career, you're not going to go through the bureaucracy of doing that to do the last 2 years of you giving back. At the very end, it was said that there was. It was said. Just let me finish.
Order. In the committee, you can speak as often as you like. So interventions need to be very short. Okay.
To finish point. Sometimes there are reasons. Sometimes people want to give back, and by making it harder for them to go into state schools, it's state schools that will miss out, not independent schools, not others, but it's just state schools that will be missing out.
Thank you, Sir Edward. Look, the points that the Honourable Gentleman from Southampton and the Honourable Lady just now from Morecambe and Lunesdale made lead me on to, you'll be pleased to know, my conclusion, or my concluding section, which is to pose the same question actually that everybody else who's spoken on this side of the room has posed, which is why? What is driving this? What is the problem? As with so many other aspects of this bill, and we heard it in the evidence session on day one, what is the problem we are trying to solve? So I did a little bit of research, Sir Edward, and I wondered, after 14 dark years of Conservatives in government, and people being able to recruit teachers willy-nilly, a race to the bottom, blah, blah, blah. I wondered what huge number we might have reached, what huge proportion of the teaching workforce we might have reached, which did not have that qualified status which they and I and we all know has such huge value, but can be complemented with other people who have other types of expertise and experience who may come in, help to augment those brilliant teachers with their qualified teacher status. What proportion, Sir Edward, do you suppose? You don't know. I am at liberty to reveal. But after those 14 years, the proportion of the teaching workforce without qualified teacher status was 3.1%. And then I thought, well, like the Honourable Lady, the whip. Then I thought, well, maybe that is from a low base, but there must have been huge growth in these 14 years. So I then looked back to see what the proportion had been in 2010. So it was 3.1% in last year. Can you guess, Sir Edward, what it was in 2010? No. It was 3.2%. So in fact, it's very slightly shrunk over those 14 years. And in this bid to avoid a race to the bottom, I wonder what verdict colleagues opposite make on the Labour governments of 1997 to 2010 that left us with 3.2% of the teaching workforce not being qualified. I'm happy to give way.
Does the honourable gentleman have a breakdown of how many of that percentage are teachers in training?
I do.
Yeah, good.
I'm so glad she asked. I then went on to ask the same question that the Honourable Lady quite rightly came to, which was of this 3.2%. Well, presumably, therefore, most of those were on a journey. They were on a route towards QTS, towards qualified teacher status. I have in front of me the spreadsheet. So the number and proportion of full-time equivalent teachers without qualified teacher status, by whether they are not working towards, those not on a QTS route in 2010-11 of the non-QTS teachers, those not on a QTS route, was, Sir Edward, 85.6%. So, I thought I was going to do the questions. So my question is, what is the thing that has changed? Please forgive me. What is the thing that has changed, that has got worse over this period, that they think they are going to address? What is driving this being included in primary legislation? Sir Edward, what problem are ministers trying to solve?
Thank you, Sir Edward. A couple of things. I'd like to understand whether the classes that are covered by teaching assistants and cover supervisors are included in that ratio of qualified or unqualified teachers, because those things happen on a daily basis in our classrooms and are not always registered as that person's registered teacher. They're covering a class, or they're a teaching assistant that's been asked to step up. You asked again why, and I wasn't able to answer you in the beginning, but I think we still believe as a government the why is we need to ensure that all of our children are taught by qualified teachers to get the best education. And granted, during the early 2010s, the gap across all school stages began to gradually close. But since 2010, the attainment gap has widened notably, within 10 years of progress closing the gap, widening in just a few years, and that is from the Sutton Trust in February 2024.
The Honourable Lady says that, and I quote, all of our pupils deserve QTS teachers. So why is it that the government is exempting those in further education, 14 to 19 and 16 to 19 academies, university, technical colleges, studio schools, non-maintained school earlier settings? If it's so desperately important, why are they exempting the settings that have more of these non-QTS teachers? Does the Honourable Lady think that's a mistake, presumably?
No, I'd finished.
You've finished?
I don't know how I interviewed. I didn't give an intervention. I sat down.
Sorry.
Thank you very much, Mr. Speaker. I won't bore everyone with another kind of rendition of the credit of non-QTS teachers. Only to say that I spent Friday at Debenham High School, and when I spoke to the head teacher, he sighed with kind of frustration that suddenly he's got to look down the barrel at finding qualified status for some of his linguistic teachers. You know, he has a Spanish teacher who works at the high school who he's now going to need to train. You know, I know we're having an argument about immigration policy and the future of immigration in this country, but trying to stop foreign teachers coming to this country and teaching in schools in Suffolk is not where the problem is going to be solved. But my point is about costs. I read in a Policy Exchange report suggested that getting all non-QTS teachers trained was going to cost in excess of £120 million. So that's 6 times the budget that this government have allocated to solving stuck schools, on making sure we help, 6 times the budget we're going to spend getting teachers to jump over a regulatory barrier. So can the Minister confirm the estimated cost of getting teachers qualified status, whether the department will cover that cost, and whether they'll end up just burdening schools with the cost of this kind of regulatory hurdle?
David Baines.
Thank you very much, Sir Edward. It's a pleasure to serve under your chairmanship. I wasn't going to speak in this, but I've sat here in increasing bafflement, to be honest, a bit like the debate we had in a previous session around branded school uniform items, and I think most ordinary families watching this or listening to this debate will share my confusion. We've heard from honourable and right honourable members opposite time and again questions about why is this needed. For me, speaking as a parent, I've got QTS. I'm a former teacher in a previous life some 10 years ago, but I'm speaking really as a parent. I've got one child at a maintained primary school. My eldest child is at an academy secondary school. I don't care what kind of school they go to, as long as it's a good school and they get a good education with good outcomes. For me, this is about expectations. So it's about high standards. I think as a parent, I am totally entitled to expect Both my children are taught by qualified teachers. And of course I will.
You've just said two completely different statements. You said, I will send my children to a school that will deliver an outstanding education that is right for them, while simultaneously saying, but this is about making sure that teachers have qualified status. My expectation they have qualified status, whether they get a good education or not. And I bet, look, academies, failing schools that academise are 3 times more likely to improve an OSCE rating than I didn't hear that, but I'm sure it was very funny. I'm sure it was one of his funnier comments. Yeah, look, you've just made 2 different statements, so can you clarify what you mean?
I don't believe they are contradictory, because I think expecting an outstanding education involves expecting teachers to be qualified. And indeed, his colleagues have said that. They've said that, and witnesses we heard at oral sessions said the same. Of course, qualified teachers is the ideal. So I don't believe it's contradictory to say that I expect teachers to be qualified and I want my children to have an outstanding education. I think those things go hand in hand.
Would he give way on that point?
Of course I will.
If he was the parent at an FE college, would he have the same expectation? And does he understand why all these other schools are exempt?
I think in an ideal situation, of course I want whoever's teaching my children to be qualified. And I don't think that's an unfair expectation. I would just go back as well to a point that's been made. We've heard this is already the situation in maintained schools. So across St Helens North, in my constituency, I'll bring what might be the conclusion of the debate back to the start with the mention of rugby league, which I'm very happy to talk about for many hours if anyone will indulge me. But in St Helens Rugby League Club do outstanding work across the community, including in schools, both maintained schools and academy schools, with children right across the borough getting access to high-quality sports coaching. That will not change, whether it's an academy or a maintained school. That will not change. At schools across the country, maintained schools, pupils have access to specialist adults coming in and teaching them all sorts of things in the presence of qualified teachers as well. That will not change. High expectations is what this is about. And much like the debate we had about branded items, I think most parents watching this, most families watching this, will just be absolutely baffled at the opposition and the length of time we're spending talking about something which is a standard expectation that should be for most parents, that people teaching their children are qualified.
Yeah. Well, Minister, we've had a lively debate.
Thank you, Chair. So I rise to speak to amendments in Group 38 in the names of the Honourable Member for Harborough, Oby and Wigston and the Honourable Member for Twickenham, and to Clause 40 stand part. Turning first to Amendment 73, I do appreciate the Honourable Member has some concerns about Clause 40. However, this amendment could deny new teachers high-quality training and induction, which is based on the evidence of what makes good teaching during the critical early years of their careers. And more so, the amendment would also apply to local authority maintained schools and special schools, which are already required to employ teachers who have or are working towards QTS, a system that is working quite effectively, I might add. As well as ensuring subject knowledge, having QTS ensures that teachers understand how children learn, can adapt their teaching to the needs of children in their class, particularly and including those with special educational needs, and can develop effective behaviour management techniques. It's remarkable, I have to comment, that we're having to justify the importance of teacher training as part of this discussion. It's been referred to as bureaucratic hurdle a number of times during this debate, which I think those in the teaching profession will find remarkable, including parents watching this debate, as my honourable friend said. This amendment could also lead to some unqualified teachers either leaving the profession or moving to another school before the 5-year deadline, which is what the honourable gentleman's amendment suggests, rather than gaining the training and support to which all teachers should be entitled. It would risk a negative impact on both the quality of teaching and the retention of teachers. We recognise that schools will still need some flexibility, so we're updating regulations to clarify that schools will still be able to recruit an unqualified teacher These teachers will have 3 terms to secure a place on an appropriate route to qualified teacher status, and it will make sure that schools' recruitment processes for teachers are not held up in any way. Turning now to Amendment 74.
Will she give way? Just
I will give way.
On a factual question, I probably should know the answer to this. Are those regulations published?
Minister.
Those are the regulations that are already in place for the maintained sector, and they'll be updated to apply to the academies sector also. Turning now to Amendment 74, and I appreciate my honourable friend's intention to ensure that this does not impact the working arrangements of unqualified teachers already working in academies. We agree that this requirement should not impact on existing employment arrangements in academies, but we need to do it in a way that doesn't inadvertently affect the way that legislation already applies to local authority maintained schools and special schools. We will, subject to the passage of the bill, provide an exemption and regulations for any teacher who commences their employment with an academy, school or trust prior to September 2026. Those teachers moving to another employer after this date will then need to obtain qualified teacher status. We will set out an exemption in regulations for teachers who are employed to teach in a primary or secondary academy setting, and this will mean that we are able to provide schools with reasonable time to prepare for any necessary changes to their recruitment procedures following primary legislation changes. I turn to Amendments 75 and 94. I recognise the challenges around teacher recruitment that we have inherited. However, the solution should not be to embed lower standards for shortage subjects into primary legislation. These amendments would create uncertainty for schools and teachers, as the teachers they employ could move in and out of the requirement for qualified teacher status depending on each year's initial teacher training recruitment data. They would also change the requirements for qualified teacher status in local authority maintained schools and special schools, which are already required to employ teachers with qualified teacher status. Under clause 40, schools will continue to be able to recruit teachers without qualified teacher status for any subject, and then support those teachers to gain qualified teacher status through an appropriate route.
On this point, I'm very, very grateful to the Minister for giving me on this point. It seems to me that the government does recognise the importance of pragmatism, and that, it seems to me, is the reason they have chosen to exempt FE 14 to 19, 16 to 19, UTCs, studio schools and non-maintained school early year settings. I'd be grateful if at this point the Minister would confirm that it is that pragmatic reason that the Minister has chosen to exempt lots of different types of schools from this requirement. And I would just make the argument to her and see what she thinks, that the same arguments that have caused ministers to pragmatically exclude those whole types of schools are perhaps also an argument for excluding shortage subjects.
So, as he's aware, qualified teacher status is the professional qualification for teachers in primary and secondary schools, and currently it applies to local authority maintained schools and special schools. Under these proposals, it will apply to all primary and secondary state-funded schools in England. As he is aware, there are some exceptions to this currently within the legislation, and those same exceptions will continue to apply as this is applied to the academy sector.
But on this point,
with regard to the second part of his question,
the second point is, so the settings that the Minister has chosen to exclude, and this is a new exclusion from a new rule, let's be clear, are settings typically where the share with non-QTS teachers is higher. And it seems to me that that can only have been, we're still looking for the explanation of why some schools are different to others. And these are schools with kids of the same age, they're schools with 14-year-olds in, but some schools will have the new requirement and others will not. And it seems to me the logic, I'm just trying to get ministers to explain what the logic of that is, it seems to me a pragmatic one. Ministers have chosen, there are enough QTS teachers in these schools, they don't want to create a problem by putting their new rules onto those types of settings. There are many lots of types of settings there. And I'm just trying to make the same point about shortage subjects. I don't know if the Minister can see the connection.
I wonder if it would be helpful if I finish my comments, and then if I haven't answered the honourable gentleman's question, I'm more than happy to come back to it. But what I will do is I'm responding currently to the amendments that have been put by various members, and then I will set out the rationale for the clause that we are putting forward, and then I'll be more than happy to answer specific questions if he has them at the end, if I have not anticipated his questions, which I do hope to do. So under clause 40, schools will continue to be able to recruit teachers without qualified teacher status for any subject, and then support those teachers to gain qualified teacher status through an appropriate route. So we're updating the regulations to clarify that they will have 3 terms to secure a place on an appropriate route to QTS. And we believe it will provide schools with the adequate flexibility for the circumstances where they may need to recruit a subject expert, and that expert does not have qualified teacher status, but can be on a route to gaining it under these requirements. We're focused on ensuring that we have enough qualified teachers available for schools, and obviously the best recruitment strategy is a retention strategy, which starts with making sure that teachers who are currently teaching do have access to high quality training and they have that induction support. So we have a range of measures beyond the bill to address recruitment and retention of teachers in shortage subjects, including a targeted retention incentive worth up to £6,000 after tax for mathematics, physics, chemistry and computing teachers in the first 5 years of their careers who choose to work in disadvantaged schools. So turning to Amendment 76, I've considered the Right Honourable Member's amendment. However, if Clause 40 were amended in this way, it would specifically build in a loophole to the very changes that the clause seeks to make, and that perhaps was its intention. This amendment effectively seeks to remove the clause. Clause 40 demonstrates our commitment to qualified teacher status and the professional status of teaching. High quality teaching is the most important in-school factor for improving outcomes for all children. Great teachers need subject expertise, but they also need to understand how children learn, how to adapt age-specific approaches, how to adapt their teaching to children that might have a whole range of different needs within their class. This bill continues to raise standards and build on the reforms made by previous governments who ensured that the essential knowledge associated with great teaching is incorporated into all primary and teacher training. We want to ensure that new teachers have the benefit of this knowledge, whichever type of school they work in. Therefore, for the reasons I've outlined, I would kindly ask honourable members to all withdraw their amendments. Now turning to Clause 40, this will help us to break down the barriers to opportunity by making sure that new teachers are prepared for a successful teaching career through high quality, regulated initial teacher training, followed by statutory induction to support their professional development. It will reaffirm the professional status of teaching and emphasise the importance of high quality teaching in outcomes for children. Academies will need to ensure that new teachers entering the classroom have or are working towards qualified teacher status, followed by completion of statutory induction. The qualified teacher status requirement will ensure that both new teachers and experienced educators moving from other settings are supported to have long-term successful teaching careers and are in the best possible position to have an impact on the life chances of children. It won't apply to any teacher who was recruited and employed before the implementation date, unless that teacher moves to a different employer, and that will minimise any disruption to current academy employment arrangements. The clause will ensure that teachers who gain qualified teacher status after the implementation date complete statutory induction so that they receive a programme of support that ensures that meet standards and are well trained at the start of their careers. The clause will bring academies in line with maintained schools and standardise the approach across state-funded schools for new teachers to the classroom to have or be working towards qualified teacher status and to then complete statutory induction. And I hope that answers the question of why we are doing this. The exemptions that are currently in place, and this to allay the concerns, and I referenced this in some of the commentary earlier, the current exemptions that are already in place for maintained schools will remain and they will be extended to academies. So I hope that answers that specific question. Okay, I'm happy to take, I was going to go and answer some more specific questions, but if the Honourable Gentleman wants to put his question again, so that I can appreciate what it is.
It's just this point. The Honourable Lady talks about maintaining or continuing with various things, but to be clear, a new exemption from a new clause is being made today. And it is this point about, and it's not just about later phases of education, it's about children in normal secondary schools that the government has chosen to exempt further education, that is different, 14 to 19, 16 to 19 academies, UTC studio schools, and non-maintained school early year settings. So there's a heck of a lot of state schools that are being exempted from the things that the ministers say are so desperately important, and I just still haven't heard the reason why, if it's so important, why it doesn't apply to them too.
So, I mean, I've been pretty clear that we are basically bringing to the state school academy sector the same requirements that currently apply to the local authority maintained school sector and to special schools. Clearly, during...
on that point, I'm so sorry. She says to the academy sector, but she's not doing it to 14 to 19 academies, or to 16 to 19 academies, or to UTCs, which are a type of academy, or studio schools are also a type of academy. But so it's not all academies, as she says, it's actually only some, and I don't know why it's only some.
Okay, well, so high quality teaching is available for those that want to teach in further education settings, for earlier settings. Earlier teacher status is available for those wishing to specialise in teaching babies and young children. There is an optional professional status, qualified teacher learning and skill status, which is available for further education teachers. All of those are not the subject of this bill, because this bill deals specifically with primary and secondary schools in the state sector, which includes local authority maintained schools, special schools and academies. Obviously there are a range of city technical colleges, studio schools, university technical colleges that offer a particular curriculum or focus in some respect on a particular artistic or technical or vocational education, and obviously we want to ensure the flexibility that they require to employ specialist teachers with a range of expertise, knowledge and experience to deliver it effectively. And the intention of this clause is very much to extend the already well-functioning qualified teacher status within the maintained sector to all primary and secondary schools, so parents can know their child has a core offer. And obviously it's not just about this qualified teacher status, it's about the national curriculum, which we will get onto and I'm sure have additional debate, on the teacher pay floor and regard to conditions, to ensure that parents know that their school has a core offer and that teachers who work within state primary and secondary schools know that there is a core offer for them to work in that environment, whether they work in a maintained school or an academy school, and that there can be the clarity about what both a teacher can expect and what a parent can expect from that school. But that is the purpose of these amendments today. I can go into more detail on specifics that members have commented on, but I believe I have covered most outstanding queries within my comments, so I'm happy to leave it there unless honourable members have specific issues that they feel I have not addressed.
Do you wish to comment further?
I do wish to move our amendment 75, Mr. Chairman.
75.
And just to explain that point, if I may, very briefly, I mean, across the public sector, be it the civil service, be it the police, be it social work, we're trying to make it easier for people to come in from the outside, talented people. And yet in this field, we're moving in exactly the opposite direction. The government's offering pragmatism in some fields, but not in the case of shortage subjects. So I'm keen to move our 75.
So is everyone content for 73 to withdrawn? So we now move to amendment 75 then, where we'll have a vote, okay? So Amendment 75 proposed to clause 40 as on the amendment paper. The question is, the amendment been made? As many of the please to say aye.
Aye.
The contrary, no.
No.
Division.
Division in 10.
Okay.
Catherine Atkinson.
No.
David Baines.
No.
Matt Bishop.
No.
Ellie Chowns.
No.
Lizzie Collins.
No.
Emma Foodie.
No.
Vicky Foxcroft.
No.
Tom Hayes.
No.
Damien Hines. Catherine McKinnell.
No.
Amanda Martin.
No.
Stephen Morgan.
No.
Neil O'Brien.
Aye.
Darren Paffey.
No.
Ian Solomon.
Aye.
Patrick Spencer.
Aye.
Manira Wilson.
Aye.
So the ayes were 5 and the noes were 12. The noes have it. The noes have it unlocked. Do you wish to move your amendment or?
Amendment 94 seeks to do the same as largely the same as the amendment we've just voted on, so I'm not proposing to push it to a vote. If I could just say one sentence, if I may, Chair. I just wanted to clarify once again on record, given some of the comments we've had from members opposite, that we on the Liberal Democrat benches absolutely believe qualified teachers are absolutely crucial. The purpose of my amendment 94 was just to prevent unintended consequences. I think it's better where you cannot get a specialist teacher because there's just not one available. I'd rather children had somebody in front of them who had the knowledge to teach them than go without, and that's why we have pursued this amendment. But we absolutely agree with the government's intentions, and I was a little bit troubled that there was a suggestion that we wanted to lower standards in schools or anything like that. Qualified teachers, excellent teachers, are critical to children's outcomes. Thank you.
So Amendment 94 was finally withdrawn. We now come to the question that clause 40 stand part of the bill, which has already been debated. The question is that clause 40 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 41 stand part of the bill, with which it will be given to debate new clauses 44, 53, 54, 65 and 66. The question is that clause 41 stand part of the bill. The Minister.
I rise to speak to clause 41. Parents and children have a right to expect that every child will receive a core education that builds the knowledge, skills and attributes they need to thrive, regardless of the school they attend. Our reforms will create a richer, broader curriculum that will ensure children are prepared for life, work and the future. We want all children to benefit from this reformed curriculum. So clause 41 will introduce a requirement for academies to follow the national curriculum in the same way as maintained schools. This does not mean prescribing every last detail of what is taught and how. The reformed curriculum will allow all schools plenty of scope for innovation. It will be designed to empower, not restrict academies and other schools, and will ensure teachers have the flexibility to adapt to the needs of their pupils. The measures will be commenced only after the independent curriculum and assessment review has concluded, and we have responded to the recommendations and developed a reformed curriculum. It will give every child guaranteed access to a cutting-edge curriculum that will provide an excellent foundation in reading, writing and maths. They'll benefit from a curriculum that will ensure they lead compulsory education, ready for life and ready for work. And I hope the committee agrees that the clause should stand part of the bill. But turning to amendment new clause 44, tabled by the honourable members for Harborough, Oby and Wigston and for Central Suffolk and North Ipswich, G.K. Chesterton famously said, we should never take down a fence until you know why it was put up. The national curriculum was established in the late 1980s to ensure that children receive a broad, high-quality education. It provides a strong foundation regardless of background or the school they attend. And it's not about meeting an abstract standard. It's about making sure all children have access to the knowledge and skills necessary to thrive in society and the economy of the future. The national curriculum also enables credible national qualifications, facilitates smoother school transitions and supports accountability. However, it is not and was never intended to be prescriptive. As Kenneth, now Lord Baker, said when introducing the national curriculum, we want to build upon professionalism of the many fine and dedicated teachers throughout our education system The national curriculum will provide scope for imaginative approaches developed by our teachers. Much has changed since then, but that principle still very much applies. The amendment, by taking away that curriculum fence, could undermine the consistency and equity of education across state-funded schools at a time when we're trying to assure it. Allowing maintained schools to deviate from the national curriculum could lead to a more fragmented system where the quality and content of education varies widely. It was that problem and the lack of transparency or accountability for what our children were being taught which led to that curriculum fence being erected in the first place. And we mustn't return to curriculum decisions being taken in what James Callaghan famously called a secret garden. As drafted, the amendment could also place an unimaginable burden on Ofsted to assess curricula of any school deviating from the national curriculum to ensure high quality. And, intentionally or otherwise, this amendment would remove the requirement to deliver national curriculum assessments, including the phonics screening checks and SATs, which would undermine key quality measures, making it harder for parents to compare how well schools teach pupils and for schools to be held to account. And on that basis, I really do invite the honourable members to withdraw this amendment. Turning to Amendment New Clause 53, tabled by the honourable members for Harborough, Oakley and Wigston and Central Suffolk and North Ipswich.
Order. Committee adjourned till 2 o'clock. Thank you.